Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm the Marketing Manager at Bond. Just two quick housekeeping items to go over before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once today's webinar has ended, we would appreciate you taking a moment to complete the survey. Your comments and suggestions are important to our panelists, and they also provide us with topics for future presentations. So to start off today, I would like to introduce today's moderator, Andy Bobreck.
Good afternoon. Hello, everybody. Great to be with you. Great to be back here. We had, as you noted, some substitute hosts for us who I know led some great discussions and panels, but it's good to be back with you today. We've got a great lineup with some new faces for you to meet today. Certainly, we've had some developments in different areas over the course of the past week, and we'll be presenting on those today. Just to echo something that Kathy said, we really do look at the reviews that you send to us. So if you can take that 30 seconds afterwards, let us know what you think, how we can do better, what topics you'd like to hear us talk about. We really value your input there. As always, our panel will continue to monitor the Q&As here. We'll do our best to answer those questions for you and to be responsive. Again, we appreciate your attendance. It means a lot to us. So without further ado, why don't we get started here? Just recently, we saw some significant developments with respect to New York's HERO Act. And I say significant because I think one of the top questions I got from clients near and far over the past month has been, when are we going to see guidance and templates and plans from New York State under the HERO Act? And the good news is we did finally receive those last week. The bad news, I suppose, is that there's quite a bit of information to process in relatively short order. We had a very productive, I think, webinar for our clients here at the firm yesterday, covering this topic at length. For those of you who aren't clients and would like to attend that, well, we want you to be our clients and to join us. And we had a great session, but we wanted to invite Stephanie Fedorka. As many of you know, Stephanie's been doing a tremendous job keeping track of this legislation, monitoring for any developments, and she was right on top of this guidance as it came out. And we wanted to take a little bit of time today just to give you an overview of that information and some of the things that you need to be keeping in mind. So without further ado, Stephanie, great to have you with us today.
Andy, thank you so much for having me, and thanks for that kind introduction. I spent countless minutes refreshing on July 6th, anxiously awaiting to see if the Department of Labor would post their model standard and model plans, and surely enough, they did late into the evening. So we're going to talk a little bit about that today, as Andy mentioned. So just a little bit of background and kind of a refresh and reminder. The New York HERO Act, which is now in effect for the most part, is two components. There's two components to it. One is New York Labor Law 218B, which we're going to talk about today in depth a little bit more. That has to do with the airborne infectious disease exposure prevention plans. Became effective July 4th, and it applies to only private employers, but there is no numerosity threshold. So public employers, this does not apply to you at all, but all private employers with work sites in New York State are subject to these requirements. There was also a second part of the New York HERO Act, New York Labor Law 27D, which is discussion and involves the workplace safety committees. That becomes effective November 1st. And that applies to private employers with at least 10 employees. And we're not going to focus our discussion today. We'll handle that as time goes on and as we approach that November 1st deadline. So you can stay tuned for more information on that section. Next slide, please. So on July 6th in the evening, the New York State Department of Labor finally published a model standard and model plans related to this airborne infectious disease exposure prevention plan that is now required under New York Labor Law 218B. So we provided some links for you. The slides will be available as well. And I think Andy might share those links to the guidance, and I can certainly do so in the chat. So The first document there is that Airborne Infectious Disease Exposure Prevention Standard. That sets those minimum standards and requirements as to what needs to be included in these model prevention plans or in your plan, implementation of the plans, who the plans and who the standards are subject to, which we'll get into in a couple of slides. Then they provided a general model airborne infectious disease exposure prevention plan. So it's kind of a one-size-fits-all template that's very general. And then they provided industry-specific model airborne infectious disease exposure prevention plans that apply to the following. They have specific ones for each of the following specific industries: agriculture, construction, delivery services, domestic workers, emergency response, food services, manufacturing and industry, personal services, private education, private transportation, and retail. So if you fit into one of those categories, there are industry-specific standards and model plans, I should say, or there's the general airborne infectious disease exposure prevention plan. Next slide, please. So I think the most important thing to focus on today is deadlines. What is required of employers that are covered by this act and this section, New York Labor Law 218B. So you have to adopt a plan, a compliant plan. Employers have until August 5th to either adopt one of the model plans or to create and adopt an alternative plan that meets or exceeds the minimum standards. However, if your organization is seeking to create an alternative plan, there are special rules that apply. If you're in a unionized setting, you have to develop the plan with pursuant to an agreement with the collective bargaining representative. Or even if you're in a non-unionized setting, the statute requires this quote unquote meaningful participation from employees. It's got to be tailored and specific to the hazards in the specific industry and work sites as well. So you have those options, either adopting one of the models that may apply to your industry or the general model plan, or if you are going to create an alternative plan, again, making sure that you're meeting those minimum standards in that standard document and making sure that you're either pursuant to an agreement with the collective bargaining representative or with meaningful participation from employees. There's a verbal review requirement as well, both in the statute and the guidance. Employers must conduct a verbal review of policies, employee statutory rights, and the prevention plan itself. It's clear from the guidance that this has to happen during an outbreak of airborne infectious disease. It's a little bit less clear and could be subject to further guidance, hopefully from the Department of Labor, whether or not employers are required to provide this verbal review before any designated or declared outbreak. And we'll talk about this a little bit more in a couple of slides, but ultimately these plans are triggered by a declaration or a designation by the Commissioner of Health as to an airborne infectious disease. So it doesn't apply unless such a designation is made. So these plans kind of sit on your shelf and they're on standby. You must adopt them, but they're kind of on standby until they are activated by a designation or declaration by the Commissioner of Health. Next slide, please. There's written notice and posting requirements. Employers must provide a written copy of the adopted plan to all employees in their primary language within 30 days of adoption of the plan, or no later than September 4th. So that's 60 days from the date that the New York State Department of Labor published the model standards. So if you adopt your plan the very last day, August 5th, and you just meet that deadline, then you would have until September 4th and to provide a written copy of the adopted plan to all of your employees. As far as the primary language requirement goes, the Department of Labor currently has English copies, Spanish copies are in the works, and they have identified that they are going to provide copies of the model plans in selected languages. If the primary language indicated by your employee or employees is one of those selected languages by the New York State Department of Labor, then you have to provide a copy in that primary language. But the statute is clear that if the employee's primary language is not one of those selected by the Department of Labor, that an English copy will suffice. You have to post the plan in a visible and prominent location in each worksite. And note that there's other scenarios where employers are going to have to provide a written copy of the plan to employees. One is upon new hire to all new hires. The second is upon within 15 days of reopening when you've been closed for a period due to airborne infectious disease. So those are going to be the written notice requirements. And in addition, the statute is clear that if an employer has an employee handbook, that a copy of the plan must also be provided and incorporated into that employee handbook. There's a training requirement per the guidance. Once the plan is activated, so once such a declaration or designation by the Commissioner of Health is made that we are in, or there is an airborne infectious disease that poses serious harm to or risk to the public health, then these plans will be activated. And that will trigger a training requirement that is set forth in greater detail in the standard and in the plans as well. Next slide, please. So notably, the standard is very clear that this only applies to employers with work sites in New York State. A reminder that this covers a broad range of workers, not just your traditional employees. The definition in the statute is very broad. And it only applies to airborne infectious disease that's designated by the Commissioner of Health, as we noted. So it does not apply to things like the seasonal flu or other seasonal or endemic infectious diseases. Next slide, please. Notably, one thing that we took away from reviewing the standard and the plans, so in the standard itself, it says that it does not apply to quote unquote any employee within coverage of a temporary or permanent standard adopted by OSHA, setting forth applicable standards regarding COVID-19 and or airborne infectious disease agents and diseases. Also notable is that there's no healthcare specific model plan. So this to us is indicative that the New York State Department of Labor is perhaps taking the position that for healthcare employees, that OSHA ETS standard is going to apply and not the HERO Act standards or model plans. Next slide, please. Lastly, employers have to adopt the plan, like I mentioned, by August 5th, but the plan sits on standby. It's not activated or in effect until the Commissioner of Health makes such a designation. Currently, the New York State Department of Labor website is clear and the guidance itself is clear that there is no there is no such designation. So although COVID-19 is still with us, generally speaking, there is no designation that would trigger these plans at this point in time. So when the plan is activated, there's going to be requirements as far as implementation of the plan that you'll notice in the standard. And when the designation remains in effect, there may be other obligations and expectations of employers as well, and those are in the standards as well. So I think that's all for me. Quick update on where we are, but I think the critical piece is really to get those plans adopted, talking and consulting with Labor and Employment Council if you have questions about whether or not to adopt the model plan or create your own alternative plan, and go from there.
Stephanie, thank you. Very helpful overview. We're getting a lot of questions. We'll take a look at those during the course of the presentation here. I don't expect this is the last time we'll be talking about the HERO Act and the guidance here. Stephanie, if I hear you correctly, it seems what we have are really kind of a two-phase approach here. And phase two may never happen, but phase one, we have some initial preliminary work to do, which is to adopt a plan. As part of that, we need to figure out if we are going to simply use one of the model plans. And there seems to be a fair number of incentives to do so as part of the, at least in terms of ease and efficiency in the legislation and the guidance, to adopt that plan and then to communicate with our employees about that plan. And then essentially it's going to sit on a shelf. Do I have that all correct?
Yes, I think that's accurate. I think right now, like you said, we just adopt the plan and it sits there on standby until it's actually activated by a designation declared by the Commissioner of Health.
And I know we're getting questions about, verbal. And do you have a sense of, what the best read is right now in terms of if you need to give that verbal communication to employees when the plan's adopted? In other words, as part of the putting it on the shelf process?
Yeah, I think that's a great question. I think there is it could really go either way. I think it's very clear that there is a verbal review requirement after the plan is implemented or activated. I think you're going to be practically speaking, you're going to be providing employees with a copy of this written plan as well. And the term verbal review could be very broad. I know we mentioned this and discussed this at greater length in our webinar yesterday, Andy, but verbal could be written. It just means using words, right? So it doesn't necessarily mean oral. So it's hard for us without any further guidance what that verbal review and what will be considered compliant with that verbal review. But I think practically speaking, it may be a good to provide the written copy and consult with Labor Council about what the best way to communicate and pushing out this communication to your employees, explaining that there's this new plan but it's not activated and what that means. So it may be practical to provide some sort of quote unquote verbal review before the plan is activated, just to explain to employees what this is and the nature that it is kind of sitting on the shelf versus in effect.
Yeah, I think that's a great point. Your last one too. I think there could be some confusion on the part of employees when they get this, right? We've had a number of restrictions in place for an extended period. Those have been, for most employers in the private sector, have been lifted wholesale with very little, if any, restrictions left in place. And so when we roll out a pretty extensive plan with a whole long list of protections and procedures and safeguards, they may be wondering exactly what's going on. And part of that communication, as you note, Stephanie, I think needs to be an understanding that this is just, it's a tool that we've been directed to create. It's not in place right now and not active, but it could be in the future. That's great. And I think your point about verbal, again, we both looked it up in Webster's, right? And it's using words. I think colloquially, it can sometimes be used as oral presentation, but again, I think your point's the right one. You need to work with your labor counsel, contact your favorite bond attorney, certainly can contact Stephanie or me. You need to find a path that makes sense for your organization, that you're ultimately comfortable with. And this is not an uncommon situation that we've dealt with during COVID, where we've got a statute that's somewhat bare bones. We've got guidance that doesn't answer every question, kind of gives us some guidance, but we need to figure out a path forward. And we're already working with many clients on this issue, and I expect we're going to continue doing so. So Stephanie, thanks again for that overview. I'm sure we'll have you back, and we appreciate you. I know our clients really appreciate you keeping tabs on all this for them.
Absolutely. Thanks, Andy.
Great. All righty. Next up, we have Suzanne Messer. Suzanne is here in our Syracuse office, somebody I've had the pleasure of working with over the years, one of my favorite people here at Bond. And Suzanne is going to talk today a little bit about something that, as I've gotten into it, Suzanne, I read the headlines when it came out, and that being an executive order from the presidency dealing with anti-competitive behavior. And candidly, I read the headline and thought, well, that's interesting. I need to take a look at that. It's certainly relevant. And then as I started to dive into it, I thought, wow, there's a lot going on here potentially. So I think this is something our audience is going to be really interested in, and appreciate you being here today.
Thank you, Andy, and thanks for the intro. Yes, as you've noted, there's been a lot of headlines about this executive order. It was announced last week by Press Secretary Jen Psaki that President Biden would be issuing an executive order aimed at fulfilling one of his campaign promises of promoting competition in the American economy. The executive order was then issued on Friday, July 9th, and there is, as you've mentioned, a lot to unpack in this order. It contains 72 different initiatives directed at various topics and industries in the American economy. So, for example, one of the initiatives is aimed at lowering prescription drug prices. One is aimed at allowing hearing aids to be sold over the counter. There are initiatives relating to internet bills, airline refunds, and requiring greater competition in federal procurement activities, among many others. One of which we're going to talk about in detail today in a couple of slides is aimed at restricting or limiting the use of non-competition agreements and licensing and requiring some conformity in licensing requirements across the states. Can you go to the next slide, please? By way of background, the impetus for this executive order is contained in its prelude and an accompanying fact sheet that the White House has put out. And in broad terms, the purpose is to do exactly what the title of the order says, which is to promote competition in the economy. What the Biden administration explains is that in recent years, corporate consolidations have led to a lack of competition in our economy, which has driven up prices for consumers, drives down wages for workers, and leads to sort of a hindrance in economic growth and innovation. In addition to its 72 initiatives, the executive order creates the White House Competition Council, and that council has the obligation of working with the federal agencies to implement the various initiatives. It's led by the Assistant to the President for Economic Policy and Chair of the National Economic Council, who right now is Brian Deese. He worked for the Obama administration. He's been in the budgeting office and now is an advisor to President Biden. And the council is also made up of several cabinet members and the heads of various federal agencies. This is a whole of government approach, which means everybody's involved and everybody has a hand in implementing the executive order. What we're going to focus on today is the executive order initiative addressing non-competition agreements. Kathy, next slide, please. What is a non-competition agreement? Most of you probably know. It is a provision, sometimes a separate agreement, sometimes a provision within another employment-related agreement that prohibits an employee from going to work for a competitor or from starting up a competitive business after their employment with their former employer has terminated. Usually there's a temporal limitation and or a geographic limitation. So the provision applies for 6 months after termination of employment within 15 miles of the former employer, for example. Usually these are signed at the commencement of employment, although sometimes they're implemented throughout the employment relationship. One of the criticisms of these employment agreements, non-competition agreements, is that sometimes the employees don't realize they're signing them or have forgotten that they've signed them after they've worked for their employer for a period of time. So sometimes they take employees by surprise after they've left employment and started new employment, causing a problem for their continued wage earning and a problem with their new employer. Next slide, please. How prevalent are non-competition agreements in our economy? It turns out vary. The executive order references an Economic Policy Institute survey that was published in 2019. In that study, the EPI collected information from private sector American businesses that had 50 plus employees. They collected data for a 6-month period between March and July 2017. The study showed that almost half of the participating businesses had some employees subject to non-compete agreements. A third of the responding businesses required all employees, regardless of wages, regardless of position or skill level, to sign non-competition agreements. The EPI said that based on prior study information, there has been an increase in the use of these agreements throughout the past 5 years. Employees of all levels of education are being required to sign them. They're very common throughout the United States. Next slide, please. In addition to the non-competes, just a brief comment on licensing requirements that are reflected in the executive order and kind of go hand in hand with the non-competition initiative. Approximately 30% of jobs in the United States require a license. My job requires a license, cosmetologists require a license, nurses require licenses. Unfortunately, the requirements for these licenses don't travel across state borders oftentimes. Less than 5% of occupations that require a license are treated consistently across the 50 states. I believe the reason this has caught the attention of the federal government is because of its negative impact on military spouses. Approximately 34% of military families have a spouse or partner that work in a job requiring a license. Obviously, these families often are required to move frequently across state lines at relatively short notice because of a military order requiring the military member of that family to move. So this has made it difficult for military spouses and partners to continue their employment because of those, as a result of those moves. And the government would like to address that. Next slide, please. Focusing in on non-competition agreements. Traditionally, these have been regulated by the states, and they've been enforced at the state level. There's 3 states, California being one of them, North Dakota and Oklahoma being the others, that ban non-competition agreements in employment relationships. This has not, of course, stopped employers in those states from including the non-competition agreements. Oftentimes, their employees don't know they're banned, and they're sort of used as a tactic to enforce employment conditions. So in New York State, courts, in my experience, do not like these non-competition agreements. They are at some points and then sometimes appropriate. So for example, when employers have trade secrets, proprietary or confidential information, or have invested a lot of time, time and money in developing the skills of particular levels of employees to service them, those are legitimate business interests for which a non-competition agreement may be appropriate. Courts will enforce them in New York if they include no greater restrictions than needed to protect these particular types of employer interests, that there's no undue hardship on the employee or no harm to the public interest, and that they are reasonable in scope, both geographically and temporally. What that means depends entirely on the facts of each particular case. These will often go to litigation because it's very difficult to have a uniform rule on reasonability of the scope of a non-competition agreement. Depending on the facts, sometimes a 3-month restriction is what is appropriate. Sometimes a 2-year restriction is what is appropriate. So it varies greatly among different positions, different employers, and different courts. Courts are not the only entity in New York State that have not liked these agreements. In recent years, our New York Attorney General has gone after these agreements. Jimmy John's is a perfect example of when agreements may not be enforceable. Everybody knows Jimmy John's, they make sandwiches. Making a sandwich is really not a trade secret, even if you are a sandwich aficionado. Yet, Jimmy John's had a non-competition agreement for all employees, including low-level sandwich makers, that prohibited them from working in any establishment that received 10% or more of its revenue from sandwiches for a period of 2 years after they left Jimmy John's employment. The New York Attorney General said, this means you're stopping high school students who are working for minimum wages from working for another sandwich company for no particular legitimate interest. And the Attorney General and Jimmy John's entered into a settlement agreement back in 2016, in which Jimmy John said, okay, we won't enforce these and we won't require them going forward. And you see on this slide, there's a couple of other similar settlements that the Attorney General brokered within the 2016, 2018, and more recent timeframes, all of which address relatively low-wage employees with a lack of a legitimate business interest. There's also been various pieces of legislation aimed at what President Biden's executive order is now aimed at, limiting or restricting the use of these types of agreements. None of them have made it past committee, and none of them have been implemented in New York State. Next slide, please. What Press Secretary Psaki said in her press conference last week was that Biden's executive order will make it easier to change jobs and help raise wages by banning or limiting non-competition agreements and unnecessary, cumbersome occupational licensing requirements that impede economic mobility. President Biden has tasked the FTC with implementing the non-competition and licensing initiative. Current FTC chair is Lena Khan, and she has been on record arguing in the past in favor of federal rules limiting these employment provisions. Next slide, please. President Biden, in his executive order, has encouraged the FTC essentially to ban non-competition agreements and to ban unnecessary licensing restrictions that impede individuals from working in different states. There is an encouragement that the FTC and the DOJ work together to stop employers from collaborating to suppress wages and reduce benefits by sharing information on wage and benefit information with one another, including the types of non-competition agreements that they all use. So what's going to happen? We don't know. This is all very new. We think that it's unlikely that the FTC will in fact come across with a rule entirely banning non-competition agreements. Such a rule would definitely be challenged by businesses. There are often, as we've said, legitimate reasons for non-competition agreements if the circumstances are right. However, what I think is probably going to happen is some sort of rule limiting the use of such agreements for lower wage workers where there really isn't a trade secret, proprietary information, or particular skilled labor involved. But we still think that there will be some protection for employers who want to protect their trade secrets and their investments in proprietary systems and information. There's no particular time frame within which the FTC has to act to implement the executive order, but we will be keeping an eye on it, and we will certainly bring you updates as they are available.
Suzanne, thanks so much. Really helpful overview there. And I think for me anyway, the issue of non-competes, I kind of put it on the short list of issues to monitor for legislative developments. I think, we see this emerging in other states, and if history proves, our federal government will follow suit with respect to those, more progressive states, more employer-oriented states in New York likewise. And I think, as you know too, never a bad time to take a look at that non-compete you've got. And especially if, you're kind of using a stock one and maybe you had an attorney drafted up for you 5-7 years ago, maybe longer we see from time to time. Always a good time to dust it off and have an attorney take a look at it. And that's something I know, Suzanne, you can help with and work with clients and others here at Bond can too. So thanks for that overview. We really appreciate it.
Thanks, Andy.
All righty. So next up, we have, I'm very excited, a new face from our downstate offices. Sarah Zucco is on with us today. Sarah, good to have you. And
Thanks for having me.
Yeah, great to have you. I know you wanted to talk a little bit about an issue, and I think this falls in the bucket of we've got so many new things as HR professionals and leaders of organizations, so many new things to keep our eyes on and stay attuned to, and we don't want to miss those fundamental, very critical issues that are going to continue to be present in our everyday activities. And I know you wanted to talk a little bit about that with respect to harassment, sexual harassment, and some of the changes that we saw not too long ago in the law, both in the state and in the New York City metro area. So again, great to have you with us.
Thanks, Andy. So as many employers are reopening, some still have remote employees and some are implementing hybrid models. It's important to still remember that some workforce training obligations still are required for both in-office or remote employees. This includes the mandatory sexual harassment training under New York State law and New York City law. So both New York State and New York City has a requirement that employers of any size provide annual interactive sexual harassment training to all its employees. This includes supervisory and non-supervisory employees. And this applies even if the employees are remote. They're still required to attend this training. Since the pandemic has started in March, there hasn't been any waiver or stay on this obligation to provide the annual training. It has continued to this date. Under New York law, an employer, regardless of their size, is required to provide training within a 12-month period. This could be based on the calendar year, anniversary of each employee's start date, or any other date the employee chooses. It just has to be done within the 12-month period. However, for New York City employers, the New York City law is based on a calendar year. So December 31st is the deadline each year for that training to be completed. Both New York State and city law require employers to conduct training for new employees as soon as possible after hire. However, in New York City, the training requirement doesn't technically kick in until after the first 90 days of hire for full and part-time employees. And these employees have to work over 80 hours in a calendar year for the training requirement to kick in, which is a pretty low bar. So this means if you have an employee starting remote, that employee is still going to need training, even if you're not back in the office, if they're starting remote. With regards to the training has to be interactive. What is interactive? If it's web-based and it's online, you could have questions at the end of each section and the employee could select the correct answer. That counts as interactive. You could also have the employees have the option to submit a question online and receive an answer immediately or shortly thereafter. That would also count as interactive. If you're having an in-person training, the presenter could ask the employees questions or give them time throughout the training to ask questions and receive answers. This could also be conducted via Zoom, and that would count. You could also have a feedback survey at the end where the employees can ask questions. That would also count as interactive. What is not interactive would be an individual watching a training video or just reading a document without any extra step. That wouldn't satisfy the interactive requirement. The training also needs to include an explanation of what sexual harassment is. It also has to have examples of conduct that would constitute unlawful sexual harassment. It should include information concerning federal and state provisions concerning sexual harassment and the remedies that are available to victims. As a refresher, the standard for what constitutes harassment recently was amended with respects to the state standard. It used to be the conduct had to be severe or pervasive to constitute harassment. It was amended in 2019, and now it's in line with the city's law, which is any conduct that is worse than a petty slights or trivial inconveniences constitutes harassment. This is a much lower bar, so it makes it much easier for an employee to prove or establish a hostile work environment claim based on sexual harassment. So this standard should be in the training as well. You should include information concerning employees' rights or redress and who they should go to for any complaints and who would review the complaints. And there also should be information on conduct by supervisors and any additional responsibilities supervisors have with regards to obligations in preventing sexual harassment. The New York City law also has a few additional training requirements or topics that should be included in the training. That includes the employee's right to complain to agencies such as the New York City Commission on Human Rights and the Equal Employment Opportunity Commission, the EEOC, that it would be unlawful to retaliate for reporting alleged sexual harassment. The city also requires that topics on what bystanders should do if they witness ongoing sexual harassment. With regards to the training, only employees that work in New York State need to be trained. However, if you have an employee who works a portion of their time in New York State and then in another state, they would have to be trained as well. So if they, for instance, split their time between two states, then they would have to be trained if they are working part-time in New York. The law also contains a notice requirement. With regards to state law, every employee must receive a sexual harassment prevention notice at the time of hiring. This could be sent prior to or on the first day of work, and it can also be sent digitally via email. And they should also receive this notice during the annual sexual harassment training. The notice must contain the employer's sexual harassment policy and any information that was presented at the sexual harassment prevention training. So if the training had an outline, you could send that outline, and all this could be sent via email. It doesn't have to be hard copy. State law also requires that all employers have a sexual harassment policy that includes a complaint form that employees can use to report any alleged incidents of sexual harassment. And this also needs to be presented to employees at the time of their hire. Again, if they're starting remote, you have to make sure that you get this to them via email. if hard copy is not possible. Also, under New York City law, there's an extra notice requirement that employers in their physical workspace must conspicuously display any anti-sexual harassment rights and responsibility posters in employee break rooms or other common areas where employees gather. And this notice must be in both English and Spanish. So in sum, all the requirements, especially the recent ones that came into effect under state law in 2019, still apply, even though some offices aren't operating in person. You still have to provide your employees with the annual sexual harassment training.
So Sarah, is that about it?
Yes.
I think we covered a lot of great stuff there. Thank you. Yeah, obviously, folks, a lot going on still with that law, the developments under that law, and I think especially the new, much lower standard for claimants to establish a harassment case under state and local law in New York City. And I think as Sarah's illustrated very nicely, it really puts the emphasis on two things. One, that you have the proper policies in place and the procedures in place to address these issues as they come up. And two, that you respond in a very swift, comprehensive, and effective manner when these issues do arise. All of these changes put an absolute premium on your prompt response when these issues arise. It's something that I know Sarah works with extensively on our clients, something that all of us here in our labor department are handling on a daily basis. So great background information. Thanks again, Sarah.
Thank you.
Okay, we have a few minutes left here. Albany's still there as far as I know. Last I checked, Katie's still there as well. Katie, I'm thinking back. So am I right about this time? Katie's we do talk with each other outside of this webinar. So I happen to know that Katie likes to hike like me. And if I'm not mistaken, you were hiking a pretty big hill not too long ago, this time last year, right?
Yeah, last year I trudged up Mount Washington a year ago today.
Good for you.
Yes, haven't done that yet this year because we are now proud owners of a garden.
Okay, that was going to be my next question, if you had any hikes planned. So no, you're growing things now.
At some point, we're going to go hiking
Okay.
at some point, but right now I've got 50 tomato plants. So if anybody needs a tomato plant and you're in Albany, just send me an email because I've got enough.
Full-time job, taking care of a garden. All right, well, in your spare time then, you're still keeping tabs on Albany, huh?
That's right. That's right. They haven't given us, surprisingly, you know, with the last week, I think a lot of people were on vacation, so we didn't see a ton of updates from Albany, but Don't worry, there's always stuff for me to talk about with all of you.
All right.
So I'm going to kick it off. First, reported cases for COVID. We're seeing an increase over the past 14 days in New York alone. There's been an 85% increase in cases. Remember that 85%, it was already such a low number that it's going up. It's still going up a little bit, right? It's not a huge dramatic turnaround, but an 85% jump is still an 85% jump. We need to be concerned about that. This is primarily driven by the Delta variant. Across the United States, we're at about a 93% increase over the past 14 days. Again, this is all driven by the Delta variant. Looking at New York's vaccination rate, it's going up slowly still. 55% of all New Yorkers are fully vaccinated, and 67% of those 18 and older are fully vaccinated. So again, we just saw 1 percentage point change in each week. It's still good news, but we see some, confusion on the horizon. So first, last week, Pfizer said that they want to have a COVID booster shot, that they want to have a third Pfizer shot offered for people who have received Pfizer. The CDC and the FDA are not thrilled about their announcement that Pfizer unilaterally decided to take. They did this without really consulting the CDC or the FDA. but said that they will be going to the FDA for emergency approval of the third shot. What's interesting is that this coincides with what Israel has began doing yesterday. They are offering a third dose of Pfizer to those who have received heart transplants and people with compromised immune systems. Like I've spoken about in the past, those categories of individuals, organ transplantees and people with compromised immune systems generally, there are concerns that the vaccines aren't working as well. So we'll see if this third dose does help improve their ability to fend off COVID. Then there is a good chance that we will see certain populations receiving a third dose. But again, we don't know at this point how long the vaccines will be effective for within your body. We're still learning that. These are all very, it's relatively new because we haven't had 10 years to study it. So keep your eyes posted on that. It's not, at this point, nothing's really changing in the US. The biggest issue ultimately is that in the US, we have fewer than 50% are fully vaccinated. We have 67% of adults that have received at least one shot. But obviously, the emphasis now is on getting everybody else vaccinated before we worry about this third shot. Because the longer that more people are unvaccinated, the more likely it is that a variant will develop that ultimately renders these vaccines ineffective, which is worst possibility, worst outcome for all of us. So keep your eyes peeled on that. We will continue to watch those updates closely. A big update in the past week has been about face masks and face coverings in schools. Last week, the CDC announced that students and staff who are fully vaccinated don't need to wear masks anymore in schools. Remember, New York has its own set of guidance, so New York has to issue its own guidance to implement this. And so what New York has done is for summer school only at the moment, pre-K through 12th grade students and staff do not need to wear masks indoors, but that decision is ultimately up to each individual school district. That is not something that the Department of Health has universally said. And notably, two of the largest school districts in New York State, the largest, New York City, and the second largest, Buffalo, have still said that they are requiring masks for the summer. The mayor of New York City today said, look, keep your eyes out. We're going to have a new update in a few weeks. It will likely follow the CDC guidance for the upcoming school year. That is likely true for all of the districts across the state. I know that's of interest to a lot of you who are either from schools or if you have a kid. Also, just another update for schools. Schools no longer need to report their daily COVID numbers. I know that's been a burden for many of you. And finally, just wanted to briefly mention this because we're starting to see some questions pile in about the eviction and foreclosure moratorium expiration. For residential evictions and foreclosures, the moratorium ends on August 31st. The same thing with commercial evictions and foreclosures. The moratorium ends on August 31st. Remember, for commercial evictions, it only applies to small businesses with under 50 employees. And for each of these categories, the renter, the tenant, needs to show, or the homeowner needs to show that they are having financial hardship due to the COVID-19 pandemic. So that will be changing in the upcoming weeks. And with that, we ran 3 minutes over, but I'll kick it back to you, Andy.
All right. Well, we would have been on time if not for my, initial banter there. So put that on me, Katie. All right. Hey, thank you to our great panel today. They gave you some great information. Thank you again for attending. We will see you all next week. In the meantime, be well, be safe. Thanks.